Well, good afternoon, everyone. We're still waiting for a few more folks to join, but I wanted to start by saying thank you to everyone who is here. We appreciate you joining us for what is the second installment of our regular webinar series. At the conclusion of the presentation today, the full video of the presentation and my audio will be available on our website, along with the other installments in our series. So if you want to come back and listen to any of the other presentations we've done or will be doing, or if you'd like to come back and listen to this presentation again or share it with anyone else, please feel free to do so. And again, thank you very much for joining us today. So for those of you who don't know me, my name is Heather Walser. I'm the partner in charge of the Estate Planning and Estate Administration Practice Group here at Lavelle Law. My practice focuses exclusively on estate planning, estate administration, and elder law. So I work closely with my clients and my team on exclusively these issues. So we've got a lot to cover today, so we should probably get started. A couple of administrative points before we dive into the substance. The first is that if you have questions as the presentation is in progress, please feel free to ask them. There is a function, a chat function, where you can ask a question and I will see it and respond to it. Like I said, we are going to please just ask questions as they come up. Don't hesitate. I've also set aside a little bit of time at the end of the presentation for additional questions. So there's no need to wait until that time. Please just bring up questions as they come, because I'd like to make sure that we address them and that we are focusing on the things that you all are interested in this presentation. So to start, as you know, the name of our presentation is Estate Planning is for Everyone, not just for the rich and famous. That's a very common misconception about estate planning that I run into with some frequency. Specifically, people frequently think that estate planning and the process of planning for your eventual death, or if you become incapacitated, is something that you only need to do if you are wealthy or if you have a very complex estate or very complex issues to address. This is exactly that. It's a total misconception. Really, everyone should be thinking about estate planning and taking steps to address these issues, because once something happens to you, if you become incapacitated or upon your death, it's too late at that point. So it's very important for everyone to think through this issue and these issues and take intentional steps to deal with them, to protect both yourself and your family members. So as we're getting started here, I want to just take a look at our agenda just to give you the lay of the land on the matters that we're going to cover today. The first, you'll see is listed there as you versus the state of Illinois, and basically what that's going to be is an in-depth look at what happens if you die or become incapacitated without an estate plan in place. Basically, what is the worst case scenario? From there, we're going to move into what goals we're trying to accomplish with a good estate plan. In other words, what does a good estate plan do? Third, once we've got a good understanding of what a good estate plan does do, we're going to talk about the actual documents that you need to implement that plan. Because at the end of the day, this breaks down into having the right documents in place to ensure that you're protected and that your wishes are implemented. From there, we're going to address some common issues that come up in discussing estate planning and problems concerns and things that people will need to think through and frequently address as they do their estate planning. Then finally, I've set aside a little bit of time to respond to questions and to get into some of the higher level issues or questions you may have. So that's our plan. With all of that said, let's jump in. Again, if questions arise as I'm speaking, please raise your hand, so to speak, and ask away. Okay, so first and foremost, as I said, we're going to talk about what happens if you die without a will, and then ultimately we'll talk about if you have issues without other estate planning documents in place. So I'm going to kind of date myself in saying this, but for many years, one of my favorite television shows was Law and Order. So with that show and with any other crime drama or movie you might ever see, generally when the perpetrator gets arrested, he or she is informed, if you don't have an attorney, one will be provided for you. It's very similar, oddly enough, with estate planning. If you die without a will in place, for example, the state of Illinois functionally is going to provide one for you. There's a set of laws in Illinois referred to as intestacy, or the law of intestate succession. And under that law, any probate property that you own at your death is going to pass to the heirs that are defined by the state of Illinois. Now, this can be problematic for a number of reasons. The first is that you did not take the opportunity to name an executor or other representative of your estate. So at that point, the court is going to decide who your personal representative will be. The court will have no insight into any complications or backstories or problems that may arise with certain individuals being in charge of your estate. The court is only going to look at the person who shows up before it and decide whether or not that person, in the judge's view, appears to be a good representative. In addition, without a will in place, that representative is going to have to purchase a surety bond, which is basically a very expensive insurance policy. Next, equally important, if not more so, you will have missed the opportunity by not preparing a will to name a guardian for any of your minor children. Again, in that case, the judge will decide who or what person will be in charge of your children. And the judge will do his or her best to make a decision that's in the best interest of the children. But again, that will not necessarily be what your wishes would have been. It will be the judge's determination after your death. Finally, and very importantly, without taking the steps to prepare a will or any estate plan documents, you will have missed the opportunity to plan for estate tax. So both federal and state estate or death taxes can have very significant consequences, and they are most certainly things that you want to take active steps to plan and prepare for, as opposed to just letting them happen to you and your family. So let's dive into intestacy a little bit more. There are a lot of problems with, again, intestacy is the law in Illinois which says where your property will go if you die without an estate plan in place. One of the first problems with intestacy is that the rules often don't capture what most people would want. Here's the most sort of glaring example. Generally speaking, when there's a married couple, the vast majority of my clients, their intention is that at the death of one spouse, the assets would go to the second spouse, and the surviving spouse, and the surviving spouse would use those assets as he or she sees fit to take care of the children, to take care of him or herself, etc. Well, intestacy doesn't work that way. In that scenario, if you have a married couple with young children and one of the spouses dies without an estate plan in place, the state of Illinois says that the property has to be split, half to the surviving spouse and half to the children. Now, that can be problematic for a whole host of reasons. Even if your children are, there's no contentiousness, the surviving spouse would still have to go to court, report to the probate court each year, render an accounting, and really the worst scenario about this type of intestate succession, we call it, is that at age 18, each child would be able to take his or her share of the money and do whatever they like with it. And that's just to kind of put a flag on that. That is an issue we're going to be coming back to several times throughout the course of the presentation today. Generally, at age 18, a child is not prepared to deal with inheritance assets or money. So it's something that we want to be very cautious about and definitely plan for. In addition to just kind of the default rules not capturing what most people would want, special cases are not covered by intestacy. So, if there are estranged family members who really should not be entitled to your assets after your death, intestacy doesn't cover that. Intestacy is especially bad for people who are unmarried or haven't entered into any kind of legally recognized union. In that case, you could have a couple who have been together for many, many years, and one of them passes away and the other one receives nothing. So again, just another problem with intestacy overall, and another example of why you want to be ahead of these issues and plan for them, as opposed to letting the state of Illinois make these decisions for you. Last, as I talked about, by not preparing an estate plan, you have done nothing to protect yourself from estate tax and from probate. So first, probate. Without having an estate plan in place, like I said, with the guardianship and with the naming of the personal representative, the court is going to be in charge. A judge is going to make those decisions, and it won't necessarily be implementing the wishes that you would have had. Next, as I said, estate tax could potentially be an issue. Now, we'll talk a little more specifically about estate tax, but again, this ties back into that common misconception about estate planning only being for people who are very wealthy or have complicated estates. Basically, your estate includes all of the assets you own, including, surprisingly, life insurance. So if you have a significant life insurance policy, even though you didn't have access to it during your life, it will be included in the value of your estate for tax purposes after your death. So just a quick overview on what we're dealing with in terms of estate tax. And again, these numbers look significant, and they certainly are. So from an Illinois perspective, you have $4 million that can be passed to your heirs or to your beneficiaries without estate tax. From federal standpoint, that number is almost $5.5 million. So again, these seem like very high numbers, and they are. However, it's incredibly important to remember that life insurance and every other asset you own are all included in calculating that number. So it's easier to get up close to that $4 million or that $5.5 million than you would imagine. So as far as the big picture estate tax planning, in Illinois, it's incredibly important to plan for it and think about it, in part because without planning, on the death of a first spouse, for example, if you haven't done the estate planning and taken the steps to prevent it, that deceased spouse's $4 million exemption will be lost. That is slightly different from the federal system, in which if the first spouse to die does not use his or her exemption, the second spouse to die can actually use it and take advantage of it because it's what we call portable between spouses. So Again, I just want to touch on this issue. We don't need to delve into it unless people have questions and would like to delve into it further. The important takeaway from this portion of the presentation is just to know that without doing any estate planning, you've given up a number of opportunities, including planning for what's going to happen for your assets and making sure that your family and your loved ones will not be affected by the application of estate tax. Okay. So now we're going to shift gears a bit, and we're going to move into what we want to accomplish with an estate plan. What does a good estate plan do? So, again, we're trying to avoid the bad results we just talked about in intestacy. So 3 big things to think about in terms of big picture, what an estate plan should do for you. The first, and this surprises people sometimes, it's intended to protect you. The general understanding for most people is we're trying to make sure that the ones we leave behind, our family members, our loved ones, many people assume that what we're trying to do is protect those people upon our death, and that is absolutely true. You'll see it's the second sort of bullet point in this slide. But it's also very important to remember that in preparing an estate plan, you're also trying to protect yourself. Then in addition, another alternative that doesn't apply to everyone, but certainly for those of you who do own a business, it's incredibly important that your estate planning include planning for the succession of your business. Certainly you want to take care of your employees, you want to maximize the value of that asset. So back to the fact that what we're trying to do is protect you with an estate plan. The reason for that is because estate planning has really sort of a twofold purpose for you. The first, as I said, is to make sure that you're taking care of your family members and the ones you leave behind and making things as easy as possible for them. Equally important, though, is making sure that you have a plan in place for how things would be managed if you were to become incapacitated. It's incredibly, incredibly important to have a plan in place and to think about those issues. There are a number of ways that we can do that, and later on in the presentation we're going to talk a little bit about the actual documents that we use to accomplish the planning for if you become incapacitated. But at a high level, what we're talking about are powers of attorney for health care and for property, and also a revocable or living trust is also another vehicle that we often use to ensure that you are protected in the event of your incapacity. So second bullet point here, an estate plan's purpose is also to protect your family. That's sort of the more traditional understanding that people think about. We're going to try to avoid probate, which is a lengthy, complicated process that's expensive, generally something that we want to avoid. You also protect your family by making sure that all of your wishes are very clear and that everything is spelled out. Also, as we mentioned before, we want to avoid estate tax. So then third piece of the pie here is to think about planning for your business if you own one. Okay, so let's move on. Again, you want to think about your own safety, the well-being of your family, and the potential impact to your business. Those are all of the reasons that we need to think about estate planning, and you want to make sure that you take steps to plan for these things. So in terms of disability, it's just an important point that I can't emphasize enough. You have got to take steps to be certain that you have planned for your disability. Every single person should really take steps to handle this. An important point about that is if any of you listening here have children who are over 18, vitally important that they think through these issues. They may not have assets that they need to worry about passing to someone at their death, but it's incredibly important that they have a plan in place so that if something happens to them, you or a sibling or someone is named and can step in and assist. You know, I can tell you tons of stories about people that I've known over the years, clients whose children have had problems away at college. Maybe they get into an accident or they have a medical problem. Without a power of attorney for health care and a power of attorney for property in place, the parents can be completely in the dark about what's going on with their children who are over age 18. So I digress a little, but it's just a really important point that I want to make sure I hit. And again, getting back to this slide, the likelihood of disability, this is just a very interesting statistic to a math geek like me. At age 30, your likelihood statistically of becoming incapacitated is twice your likelihood of dying at that age. So it just underscores the fact that it is so important to think about incapacity and make sure that you have taken steps to plan for it. Okay. So from there, again, we're keeping in mind our sort of primary two purposes of planning for incapacity and also planning for if you were to die. We're going to delve now a little bit more deeply into what are the basic documents that you need to implement all of these goals that we want to achieve. So generally speaking, the basic documents that you really should be looking at having to ensure that you have a comprehensive estate plan that covers you for both incapacity and in the event of your death. You're going to want to have a will. For most people, a revocable, or sometimes you'll hear it called a living trust, is a really important and useful vehicle. Next, you need a power of attorney for health care, as I just mentioned. Also, a power of attorney for property. Next is a HIPAA authorization, which goes along with the medical or health care power of attorney. Then, for any business owners, again, vitally important that you have a succession plan in place for your business. We're not going to go into too much detail on that issue. That's sort of outside the scope of what we're talking about here today, but I raise it just to highlight how important it is to think that through if you have a business. Okay, so easy question. Does everyone need a will? Simple answer to that, yes. Hands down, yes. Everyone needs to have a will in place. So let's talk about why. What does a will do? So the will, first and foremost, provides for the disposition or the distribution after your death of what we refer to as probate property. Probate property is anything that does not have either a joint owner or a beneficiary designation or some other way that it would pass on your death. So sometimes it's easier to describe probate property by saying what it is not instead of what it is. So here's an example. A life insurance policy, an IRA, a 401k, any kind of investment vehicle that has a named beneficiary where if you died, that beneficiary would basically inherit the asset. That is not a probate asset, and your will would not govern it. Anything that does not have that type of beneficiary designation or a joint owner is going to be considered probate property. So best example is real estate. Real estate can be very problematic if you do not have some sort of structure in place to make sure that it's going to pass to the people that you want it to pass to. So real estate is probate property. Anything that doesn't have a beneficiary designation or some other structure that would cause it to pass at your death is probate property. So your will is going to cover that probate property. So with respect to that probate property, your will specifies exactly what is going to happen to that probate property after your death. Another incredibly important sort of issue that a will has to take care of, and that under Illinois law you do through your will, is naming a guardian for any minor children. For a lot of my clients, that is the biggest concern and the biggest issue that they really want to solve in doing their estate plan documents, because that's a real problem if you pass away with young children and there's no one named to take care of them. That's the type of issue that keeps people awake at night. So you use your will to name a guardian to care for the minor children. As I touched on a little bit earlier, you also use your will to name the executor, the person who will be in charge of making sure that your will is implemented. And you also waive that surety bond, that insurance policy, that expensive insurance policy that I mentioned earlier. So also important to know, though, that there are a lot of things a will does not do. A will does not prevent probate. If you have probate assets and you have a will, that's great, but basically you are still going to have to go to court for the judge to oversee the implementation of your will. It doesn't allow you to disinherit your spouse, which is just kind of an interesting point of Illinois law that I raised just briefly here. But the big issue that I really want to touch on with respect to what your will does not do is govern your assets if you become incapacitated. Your will does nothing until you die. It's basically just a document that sits in a drawer until the day of your death. So it does nothing to plan for your incapacity. It really doesn't take effect at all. It has no legal effect until the actual date of your death. So I say that as a lead-in to our next slide and our next issue, the revocable or living trust. You may have heard of this. It's pretty kind of part of the common knowledge of estate planning that's out there, but it's a very, very important vehicle for planning your estate and for implementing your wishes and taking care of both the goal of planning for your estate after your death and the goal of making sure that you are squared away if you were to become incapacitated. So let's talk about what a revocable trust is. A revocable trust is basically a legal instrument that you create during your life. So like a will, it is just a document, but unlike a will, it actually comes into existence and takes effect while you are living. As of the date you sign it, your living trust is a separate legal entity that is existing and in place. So, how does it work? It is administered totally for your benefit, meaning the money is still yours. You act as the trustee, which is the person who is in charge of managing everything, making decisions, investing, buying, selling. The trustee is in charge of all of those things. You manage the assets just as if they were still in your individual name. You can buy things, you can sell things, you can vacation, you can gamble, you can do whatever you would like as long as you are doing it in the name of the trustee as opposed to in your individual name. So practically speaking, having your assets in a trust while you are living and you are able to manage your affairs has very little impact on your life. You still manage things just as you always have. For example, you still will report income on your regular tax return just as you always have. You will still get the property tax exemptions for your real estate, so your homeowner's exemption, or if you have a senior citizen exemption, longtime homeowner, any of those things do not change by virtue of your assets being in a revocable trust. So that said, upon the point at which you do become incapacitated, in the event that that happens, it's a seamless transition. The successor trustee can step right in and continue to manage the assets just as you did during your life and during the time in which you were not incapacitated. So that's a crucial point that, again, distinguishes a trust from a will, in that it provides a mechanism where there's a person in place that you have chosen who will step in and manage the assets for your benefit if you are incapacitated. No need for court involvement, no need for a judge to make any decisions about who's in charge or what's going to happen to the property. Another feature or issue with a trust is that during your life, the assets need to be transferred into the trust. We call this trust funding. Practically what that means is your home, for example, if you own real estate, it would be transferred into your trust during your life. So I have a question that just came in. This is a great question, and I'm glad that you asked it, Joan. So thank you for asking. Her question is, can you define incapacitated? Absolutely. It's a very important issue, and a lot of things are keyed off of it. Basically, incapacitated means from a mental standpoint. It has nothing to do with physical disability or physical incapacity. It's purely the lack of the mental ability to manage your affairs. It's kind of a nuanced question because there are different types of incapacity, but big picture, for purposes of your estate plan, it boils down to whether or not you are able to make good decisions about your finances, managing your property, and about your health care. So that's what we're talking about in terms of being incapacitated. It's purely from a mental standpoint and a standpoint of being able to manage your health care and your financial affairs. So I hope that helps give a little more insight into where the rubber sort of meets the road on these questions. In my experience, they can be a little bit thorny. As people begin to possibly lose capacity, but practically speaking, we're just talking about when you are no longer able to manage your affairs. Okay. So then, as far as we were talking about funding the trust, we had another question that came in about trust funding. So, Curdy, thank you for asking that question. When does the trust funding take place, and how is this done? It's done during your life with the assets that you own. So that can be done in a number of different ways. As I said, as far as real estate is done via a deed, generally a quitclaim deed, transferring the real estate into the trust. For other assets, it can be as simple as retitling the bank account. Let's say you have a bank account or a stock account. You go to the bank or you go to your financial advisor and retitle the account and the asset in the name of the trust. Another good question that just came in is a question about designated beneficiaries, and this is another kind of avenue for trust funding. As I mentioned before, when we were talking about probate versus non-probate assets, some assets that you own may have a designated beneficiary. In some cases, the best route may be to name your trust as the designated beneficiary of the asset. Now, this is it can in some circumstances be a complicated question, and it's something that I was going to touch on a little bit later, but now's a good time. For certain types of assets, 401ks, IRAs, anything that is what we call a deferrable retirement account, an account where taxes are deferred until a later date, we have to be very intentional about naming the trust as the beneficiary of those type of assets. The upside with those type of assets is there can be a tax upside or a tax benefit to stretching those assets out over a longer period of time, because then you can defer the taxes longer. It's very important in a case where you want to name your trust as the beneficiary of a deferrable retirement benefit, very important to make sure that your trust qualifies as what's called a look-through trust or a see-through trust. So that's kind of a higher level point that we can go back to at the end if we have time and if people are interested. But trust funding can occur in a lot of different ways. But generally, you want to do it during your life, and you do it either by retitling real estate, renaming or retitling bank accounts or stock accounts, Or another alternative is to name the trust as a designated beneficiary of a retirement account or life insurance, anything that has a beneficiary designation. Okay. So let's talk about your revocable trust after your death. Just as it works during your incapacity, after your death, a successor trustee would simply step in and manage the assets after you die. So at that point, generally what is occurring is the assets continue to be held in the trust for the benefit of the surviving spouse and or for your children. So in some cases, there's a little bit of overlap, as I said, with the beneficiary designation. You are naming the trust as the beneficiary during your life, but the assets don't actually move via that beneficiary designation until your death. So we have a question about a trust being funded only at death. Is that a bad idea? So in some ways, yes, and I'll tell you why. Anthony, thank you for bringing up this question. The problem with not funding a trust at all during your life is that you can basically take what was a vehicle for avoiding probate and force your assets to go through probate. The reason that would happen is because if the assets are not in your trust at death, your will is going to say, anything that's not in my trust at my death, put it into my trust. Now, there's a way that you can transfer assets into your trust, and now we're back talking about probate assets, just to be nitpicky. We're talking about probate assets here. If the total value of the probatable assets outside of your trust at your death is more than $100,000, your trustee and your executor are going to have to open a probate. So in order to transfer the assets from your individual name at your death and into your trust, they would have to go through probate. So the problem with not funding your trust during your life is that you've lost out on one of the biggest benefits of a trust, which is probate avoidance. So really important to make sure that you have intentionally thought through the assets and transferred them to your trust and fully funded your trust during your life. So moving back to, you'll see on this bullet point, that's why we say a fully funded trust will not be subject to probate. Incredibly important. Last kind of benefit or bullet point we want to talk about with respect to trusts is what they do with the assets after your death. They can be used to protect and manage the interests of your minor beneficiaries or children with disabilities, anybody for whom it would not be a good idea for them to receive assets outright. As I mentioned before, as a general rule, an 18-year-old kid is in no position to manage a significant sum of money. I have yet to find, maybe there's an exception to that rule somewhere, but if so, I've yet to find him or her. Very difficult for young kids like that to make good decisions about money. So using the revocable trust structure can give you a mechanism to make sure that those assets are managed for the best interest of your children or other beneficiaries. Okay. So let's talk a little bit more, in a little more detail about that, about gifting to your children via your revocable trust. So without the proper provisions in place, as I mentioned before, as soon as the kids turn 18, if they're the outright beneficiaries, they're going to be able to take the assets and do what they choose with them. This can be problematic. You'll see later on I refer to this as preventing the Maserati. I had a law school professor who joked about this. You know, an 18-year-old who inherits a large sum of money, we want to prevent them from going out and blowing it all on a Maserati. So something we want to really think about, and a trust is a fantastic vehicle for doing that. The trust provisions can be structured in such a way that the children can only receive distributions maybe at a certain age. Maybe you decide, okay, at age 25, they can have 1/3 of the money. At age 30, they can have half of what's left. and age 35, by then they should be mature enough to have it all. But again, on that point, the world is your oyster, so to speak. You can choose whatever structure you want in terms of holding back the assets for your children. In addition to that, you can, via the trust, you can give the children access for something called what we refer to as HEMS, health, education, and maintenance and reasonable comfort. Those are IRS standards. And it's just another way to make sure that the children are provided for, or that the beneficiaries are provided for, and they're not going to be having any problems or starving, but that the money is being managed by a trustee for their benefit. Okay, so moving to the next slide, again, we're coming back to the tax planning issue. As I mentioned before, estate tax is going to kick in over those certain thresholds, $4 million and $5.5 million from a federal standpoint, $4 million for Illinois. The way that we address that is with trusts, basically. We use the trust as a vehicle for preventing the application of estate tax, or at least minimizing it. So let's take a step back in terms of going back to managing the assets for the children. So HEMS, as I said, is a way to allow the children or the beneficiaries to have access to the money for their benefit. And they can be applied to adult children. This is a great question. A question came in, can HEMS be applied to adult children who are incapable of this responsibility? Absolutely. This is something that's a great mechanism if there are adult children who, for whatever reason, be it a disability, a drug problem, a spending problem, sometimes the problem can be a spouse, a difficult spouse, those types of issues. You can absolutely have this HEMS standard apply to your beneficiaries regardless of their age. So one of the great benefits about setting up your estate plan using a revocable trust is that you really can structure the trust in any way that you think is beneficial to your children or your ultimate beneficiaries. And as a side note to that, you do not need to treat all of your beneficiaries the same way. You can structure the trust so that maybe you have one beneficiary or child who is very responsible, very squared away, and another child who maybe has some problems. You can structure the trust such that the child who is responsible and squared away, he or she will get his or her money right away, whereas the less responsible child, or maybe just the younger child, would have the assets managed for their benefit for a longer period of time. So takeaway from that is that these provisions can be very, very flexible to address whatever your particular circumstances are. The most important point is that you think through these issues and do something to address them. Okay. So moving on to our next issue, we're going to go back to the incapacity point and talk about the documents in addition to the revocable trust that are important for incapacity. The two biggest documents on that score are your powers of attorney for health care and property. So your power of attorney for health care is the document that you use to name an agent who would make your health care decisions if you were unable to do so. So we're going back to that incapacity question. And if you are in a position where your physicians feel that you cannot make your decisions and you are not capable of making good decisions, at that point, the agent you name under your power of attorney for health care would step in and make your medical decisions. Over the years, over the last 15 or 20 years in Illinois, the power of attorney for health care has developed to replace what we used to do, which was called a living will. You may have heard of that. And a living will basically was just a document in which people would try to call out for each specific scenario what the doctors should do for them. For example, things like, if I am in a persistent vegetative state, you should pull the plug, that type of thing. Those became problematic because the doctors had a duty in the absence of a specific instruction in the living will to keep people alive via extraordinary measures, regardless of family members arguing and saying, you know, my mom would not have wanted this. The living will governed, and if it didn't address the specific situation at hand, the doctors would keep the patient alive or continue medical treatment. So the power of attorney has developed over time to really address that and solve that problem. So what you're doing, again, is just naming a specific person that the that the doctors, would look to make medical decisions. Interestingly enough, the power of attorney for healthcare agent is also the person who would make decisions about burial or cremation or any of those things that in Illinois we refer to as disposition of your remains. So it's just an interesting side note about that, that particular document. So in a similar fashion, the power of attorney for property names a person as agent who would step in and manage your financial decisions if you were unable to do that. People often ask me, well, okay, if I have a trust and my trust is funded, why do I need a power of attorney for property if the successor trustee can just step in when I'm incapacitated? It's a very good question. The reason that you would need the power of attorney for property is even if you have a fully funded trust with all of your significant assets titled in the name of the trust, there are still going to be things that fall under the property power of attorney that are not in your trust. So things like, you know, from things as simple as your utility bills to hospital bills, any of those types of things, your power of attorney agent would be the person who would have to handle. In addition, a much bigger issue is that your power of attorney for property would be the person who would work toward attaining government benefits for you if you are incapacitated and maybe Medicaid is an issue or Social Security, any of those types of things. Your trustee cannot handle those issues. Your power of attorney for property agent does. So from that standpoint, it's very, very important that you've named a power of attorney for property. And again, going back to if you have adult children, college age, anyone over age 18, they really should have these two documents in place 100%, a power of attorney for healthcare and a power of attorney for property. So quickly, I want to just touch on what would happen if you did not have those powers of attorney in place. I mentioned earlier that many times having no plan in place for incapacity is worse than having no document in place. So for what happens if you die. In the case that you become incapacitated without a power of attorney in place, at that point you would have to go to court. Your loved ones or your spouse or whomever is going to be managing your affairs would have to go to court and get guardianship over you. So a good question just came in. What's the difference between a plenary guardian and a power of attorney for health and property? It's a very timely question because it's exactly what we're talking about here. If you have a power of attorney for health care and a power of attorney for property in place and you become incapacitated, there won't be any need for a guardian. It basically replaces that issue and covers that issue. If you don't have those documents in place and you become incapacitated, someone is going to have to go to court and be named guardian over you. There are two types of guardian of the person and guardian of the estate. You'll see from the slide. Guardian of the person basically is taking the place of your healthcare power of attorney. Guardian of the estate is really taking the place of your property power of attorney. So avoiding guardianship is incredibly important because it's a painful process. I mean, we certainly handle plenty of guardianships here and we do a fantastic job of it, but they are not a fun process to go through. So that's big picture. That's sort of the 10,000-foot view on what will happen if you do not have these powers of attorney in place. Okay. So there are a couple of questions going back to the trust and to probate. So let me just jump in and handle these. So the question is having the probate assets below $100,000. In the event, as we mentioned before, if your trust is not fully funded, you may be subject to a probate proceeding. However, if the total probate assets outside the trust are under $100,000 in Illinois, there is an expedited process called a small estate affidavit that can allow the transfer of the assets without a probate process. So then we're going to now dive into the question about naming fiduciaries. Now that you sort of know the big picture about how these documents, the interplay between these documents and the documents that you need, you know a little bit more about the types of people that you need to name. A successor trustee who manages the trust, an executor who would handle the administration of your will, and then your power of attorney agents. You understand sort of generally what the roles of all those people are. So it's really important as you're naming these fiduciaries to think about the jobs that they're going to be doing and make sure that you choose people who are going to handle those responsibilities well and who are situated to do that. So a question came in, is the assumption that you should only have a single successor trustee and a single power of attorney for health care? So those are two really good questions, and the answers are different. So in terms of choosing a successor trustee, you absolutely can have what are called co-trustees, meaning your two children, for example, would act together as trustee as opposed to just one of them being in charge. That can have some downsides, certainly, particularly when you only have two co-trustees, because if they disagree, they can sort of be deadlocked, where one wants to do one thing and the other wants to do something else. But know that under the law, you absolutely can name co-trustees to act together. Now, that is distinct from the power of attorney agent. Under the Illinois law, for both the healthcare power of attorney and the property power of attorney, to comply with the Illinois statute, you really cannot name co-powers of attorney agent. And the reasoning for that makes sense. If you are in an emergency type situation as a policy matter, doctors or bankers or people who are relying on your power of attorney, they don't want to be having to referee a fight between the two co-agents. So the Illinois statute really just provides for one agent to act at a time. Now, that said, you certainly want to name multiple agents in the event that the person that you named is unavailable. So we would name successor agents under your power of attorney. For example, maybe you name your spouse as the primary and your children in succession as the others. Okay, so moving on to the next issue we're going to discuss. We're going to talk a little bit about some common kind of goals in estate planning or challenges, things that you want to address or think through as you are preparing your estate plan documents. So a big one that we often talk about is planning for your children. That's something that people often discuss with me and they really want to think through. And for children or for minor beneficiaries, maybe nieces, nephews, friends who are younger, we like to think it breaks down into three main goals, I like to say. You want to protect them from themselves, protect them from each other, and protect them from spouses. So the first, in terms of protecting them from themselves, so to speak, it's, as we were talking about before, with managing the assets for their benefit, preventing them from blowing all the money on a Maserati, and having someone in place, the trustee, to make good decisions and provide for the children, for their hems, as we said before, but also make sure that good money decisions are being made and that the money is being managed in an intentional way and not just being spent frivolously. So that's one of the big goals we think about with children in terms of protecting them from themselves. Next big picture issue that I like to talk through with clients is protecting your children from each other. It may not be an issue. Your children may get along beautifully, but you'd be amazed after the stress of grief and the fact that money is involved, frequently it brings out the worst in people. Having a clear estate plan in place just absolutely does a lot to head off at the pass any potential arguments, infighting, and disagreements. We even had a client in one case where the family had always been very contentious and the children had never gotten along, and the matriarch of the family had laid out a very, very specific estate plan, and the children came to us after the fact and said they had never gotten along better. And believe it or not, the mother's estate plan didn't even treat them all the same way. They each got different shares of the estate, but the fact that everything was very, very clear makes things, it takes a lot of the disagreement and the guesswork away. So last is an issue that a lot of people don't often think about. So, I'm always here to bring up the bad news and the things that you should think about that maybe are not the best result. Protecting the children or the beneficiaries from spouses. And that can be two things. It can be protecting them from their own spouses. Maybe they have a spouse in the picture that is not good with money or could potentially be pressuring the child to use their inheritance for things that are not in the child's best interest. The other piece, and this is the one that people don't frequently think about, is protecting the child from a subsequent spouse. So we see it with, I won't say frequency, but occasionally we see this scenario where someone passes away and the surviving spouse gets remarried. It's something to think about in terms of making sure that the second spouse doesn't get all the assets to the exclusion of the children from the first marriage. So just those are three kind of big picture goals that we often address or want to think about in planning for your children. So next, there are going to be different stages of your life as you're planning, and each stage has a different goal or objective in terms of your estate planning. So, for example, your wishes or your planning when you're young and it's your first marriage and you have very young children, it's going to be very different than later on in life when maybe there's a second marriage situation and children from both marriages potentially. Those sort of issues and goals and objectives are going to be very different from one another. In addition to that, there's a phase of life in which you're maybe approaching, dealing with a well spouse and an ill spouse, preparing for incapacity, long-term care, Medicaid and government benefits. So the important thing to remember from this slide and the takeaway is that estate planning is not a one and done situation. Again, it's not just for people with very complicated estates or with large amounts of assets. It's for everyone, and it's important that you address it and look at it over time throughout the different stages of your life, because the decisions you make at one point may be different from the decisions you make at a later point. And the most important thing is to actually be intentional about these things and make decisions about how you want them to go. So that really wraps everything up. If anyone else has any additional questions, please do feel free to raise them at this time. As I said, this is something that we do frequently here and well, and it's something that everyone should look into. In terms of working with us specifically, we really make it a priority to focus in on your wishes and implementing them and making sure that you are prepared. And actually, I'm glad this came in. We have a question: what actions here help with estate tax? So that's a pretty big picture question, but ultimately it has to do with the way that you fund the trust after your death and take advantage of the exemptions, the estate tax exemptions. Another quick question is, who declares someone mentally incompetent? It's typically, under the powers of attorney, it's the physician. The physician who is treating the patient would be the one who would make those decisions, okay? So again, I want to thank you all so much for being here. I really appreciate you listening in, and all of my contact information is available at the end of the presentation. Please feel free to shoot me an email if you'd like, or find us on our website, Twitter. We can be found in all these varying ways, and I would be more than happy to answer follow-up questions for any of you, for me, or for my team here at Lavelle.